right, it's Daybreak 92.5 Fox News 239-479-5592. That is the phone number and the text line. Of course, you know, streaming live on YouTube. Make sure you subscribe to our channel, Drew Steele Radio, Steele with 3 E's. We appreciate that. So we find out yesterday that the Minnesota Attorney General, Keith Ellison, is reportedly expected to upgrade charges, as he did, against one of the 3 or 4 officers there in Minneapolis. We know as well that the 3 others have been charged. But there is a question that I had thought about. And then I started to read about it. And then I thought, well, maybe we need to dig into these details. You know, Keith Ellison, the Attorney General, did up the charges against one of the officers from third-degree murder to second-degree. Let's get into the specifics, because this could have a lot to do with what we might see moving forward with regard to the prosecution and what they can and can't do, or what they will be able to do. Will it be more difficult? People have been asking me, so I'm not going to tell you until I talk to Amy Swearer, because she knows. She's a legal fellow at the Heritage Foundation, heritage.org, someone who is a great follow on Twitter, by the way, and she has written about this. She's talked about this. And so I'm so happy to have Amy on the program with us today. It's Drew Steele. How are you this morning?
I'm good. Thank you for having me.
Well, I appreciate you getting up early and joining us today. You know, there are a lot of people that have looked at this, Amy, and maybe you can speak to this directly. First of all, what were the charges originally, and was it a good move to up these charges?
So the original charges against Officer Chauvin were third-degree murder and then second-degree manslaughter, which is a very low charge, all things considered, that second-degree manslaughter. So people are really focused on, what is this third-degree murder charge? And the important thing to remember here is that even though it sounds like they've moved it up, that they might now be overcharging, I think the better way of explaining what they've done is that they've taken a charge that was actually inapplicable, that as a matter of law they couldn't have gotten him with, and they've given him now a more appropriate charge that at least as a matter of law they can pursue reasonably without worrying that it's going to get thrown out in court.
Okay, that's interesting, because it seems like people were talking about the opposite, and maybe you can explain, because people were concerned that there would be an overcharge here, that if you were to reach too far and to say, let's, for example, people have been talking about intent to kill, and how could you possibly prove that? You're saying that there was a charge before that would not have been, explain how that would not have been applicable, or how that would have been tougher than where we are now.
Sure. So first things first, I agree with you that looking at any sort of charge that would have required intent or premeditation would have been incredibly difficult to prove. It would have been overcharging.
Right.
But when you look at third-degree murder under Minnesota state law and how Minnesota courts have interpreted it, it actually doesn't apply to this type of situation. So third-degree murder is for things like DUI that causes the death of another motorist. It has to be sort of this general disregard for life generally, but what we see in Officer Chauvin's case is a specific disregard with actions specifically directed at one person, and it would have been thrown out because it just does not apply for sort of what that statute covers. And I know people have been worried about, okay, well, second-degree murder requires intent, but that's actually not true. So there's a route for second-degree murder in Minnesota that is also known as felony murder, and it's an unintentional type of death where basically the argument goes like this. Officer Chauvin used excessive force, and it actually became felony assault, just like if you or I were to beat up another person in that sort of way.
Okay.
And that because George Floyd died as a result of that assault, that's actually unintentional second-degree murder. So it's a much more fitting charge. It's a charge that, just in terms of how the law works, is actually appropriate here.
Because I know that people, Amy, were saying to me that they looked at murder in the second degree in Minnesota, and they said, well, the things that jump out off the page for them was that one of the subdivisions was intentional murder,
Right.
So the intent to affect the death of the person, but without premeditation, that's something you might move aside and say, okay, we can get rid of that. The subdivision 2 would be unintentional murders. That would be something that would be while committing or attempting to commit a felony offense. Obviously, that's not something that's going to be affected against the officers, so you would put that aside. So you'd have to have an intent to kill, but without premeditation, or if it's unintentional, a killing in the course of committing another felony. So that's where people got confused. Does that make sense?
Yeah, no, absolutely. I think you're right in saying that, honestly, what I've seen is a lot of people didn't even get past the first clause there. They just assumed it required intent.
Right.
But so the argument for unintentional second-degree murder, and again, where I think people got confused here is in a lot of states, this isn't actually an argument that can be made. But in Minnesota, so if the state can prove that Officer Chauvin was using excessive force to a degree where he is not actually authorized by the law to be using that force, that's actually felony assault. And if he's committing felony assault and George Floyd dies because of it, that is unintentional second-degree murder in the state of Minnesota. And I think that's where a lot of people were getting confused about, what does that second clause mean?
Right. Amy Swearer is joining us on Daybreak 92.5 Fox News. She's a legal fellow with the Heritage Foundation, heritage.org, a fantastic website, as you know, as we talk about often. And we're so happy that she's joining us explaining these upcharges in the George Floyd case against one particular officer, the officer that had his knee on George Floyd's neck. I guess Amy, the one thing that everybody can agree on, and this is where this comes into play, is that nobody wants to see this get messed up. In other words, everybody wants to see
Right.
that they understand that they across the board uniformly. Everybody sees that this was wrong. Everybody sees a problem here. They just don't want to have anything happen while this case is going on, where the prosecution could get themselves in a position where they could lose this case somehow, and that's the fear. And that's the other part of what I wanted to ask, which is how people have been reporting about the chemicals in the autopsy and the chemicals in George Floyd's system. The idea that he had coronavirus, the idea that he had fentanyl, a small bit in his system, and that people are saying, well, it's almost as if now there's sort of being a case that could be made or built to say, well, he had circumstances, he had comorbidities, he had some issues where you could almost make the case, and I'm just saying this is what people are asking, that's why I'm asking you,
Right.
that you can almost make the case that that's where the defense is going. Does that make sense?
Sure. So it does seem as though that might be sort of something the defense wants to cling on to. But what's important here is that the legal argument actually hinges on those several minutes after George Floyd becomes incapacitated. So this is not a case where, the officer can say something to the effect of, I didn't know he had these issues going on. Because at a certain point, when you watch this video, George Floyd is unconscious. He is literally not breathing. And at that point, any sort of argument that you have for saying, I didn't know there were underlying issues, at that point, a reasonable officer knows that there is something happening. And any sort of argument for, I still needed to use force, this type of force at this time, sort of goes out the window. And again, what you see then is for almost 3 more minutes, Officer Floyd continued to apply that type of force to a man who's clearly struggling to breathe, if he's still breathing at all at that point, but who is clearly unconscious, clearly not fighting back, not resisting at that point. And so, again, that legal argument hinges on those minutes where any one of those arguments simply no longer applies because he knows something is wrong.
Yeah. What about the other 3 officers? Do we know the charges, or what do you feel like the charges could be for a prosecution against the other officers?
So right now, all 3 of them have been charged with aiding and abetting, and so that would apply to the second-degree murder charge. I think that this is a pretty reasonable charge, and I think sort of the strength of that argument is it's gonna be very fact specific to what each of those officers was doing when, and so it's hard to make a case for all four sort of in a broad sweep because it is very fact specific about what each officer was doing.
Right.
But I think it's at least an appropriate avenue in terms of charging decisions.
Right. And I don't know, I have a couple of people that were asking me about manslaughter charges or manslaughter, how that, what can you explain to folks that are texting me right now because they keep asking manslaughter? I'm not sure why, but maybe you can explain.
So the manslaughter charge, I think, seems like a pretty slam dunk charge, which I think is a good thing. The problem with manslaughter, and again, I don't want to sort of jump the gun about what a jury will or won't do, but it seems very applicable to the situation. I think the issue is it's a much less serious charge. When you look at, time he might serve with a max sentence and good time, it comes out to about 6 years in Minnesota. And so I think a lot of people, both because murder to would apply and because it's a more serious charge, sort of putting a social distinction about how serious his actions were, that at least pursuing murder to is appropriate. But manslaughter to, which is what he has also been charged with, it's not a bad charge. I want to make that clear. It is applicable. It's just less serious.
Right. So is that where maybe you can speak to this? How could you say that there isn't? So that's where the political aspect of this plays in. There's a slam dunk charge that's out there, but is it enough for people who want to see justice done and feel like it should be more? Where Keith Ellison comes in, the Attorney General, and says, I'm going to give you more, but now they have to make sure that they have a case there that they can win. So I think that's where people look at that leap, right, and say, well, the politics are at play here, and then they're worried about that they could possibly lose this thing altogether.
Well, so it's important to remember, so he can be charged with both. And so it is possible. It is possible that even if murder 2 fails, that the more serious charge fails, that he can be convicted of the lower charge.
Right.
And this is also important. He can also be charged at the end of the day, regardless of what Minnesota does, he can be charged with federal crimes under federal civil rights violations, which are also pretty substantial. And I think you saw that happen way back in the 90s with the Rodney King trials as well. So he's not exactly off the hook in any sort of capacity, even if murder 2 fails.
All right. Well, that was great. I appreciate your insight. Amy Swearer joining us on Daybreak 92.5 Fox News, legal fellow at the Heritage Foundation, heritage.org. I encourage you to go to the website where you can find out more about her and some of her opinions, thoughts on this case and others. And we appreciate a few minutes, Amy. I hope that we can do this again. Maybe we can have you back. We could follow along as the case moves forward. We'd appreciate that.
Yeah, thank you so much for having me.
Drew Steele.